Okay, I said I was going to do this in one take, but I'm on take three, so I think I'm going to just try to barrel through it. I want to explain what I mean when I say the verdict in this trial doesn't matter. The trial matters, but the verdict doesn't, and let me explain why. People who believe in the right of self-defense understand, a number of things to be basically self-evident. First of all, the law is pretty clear around the nation that you have to use reasonable force in order to protect yourself, but it doesn't mean you can't bring a gun to a knife fight. So, the reason I say this trial doesn't matter is because what the prosecution's trying to do in this trial is use bias to influence a jury and to convince a jury that Rittenhouse should not be permitted to use a firearm to defend himself against older, stronger individuals or people who are carrying objects that could be used as metal clubs against him. Most people would say, well, that's unreasonable. You shouldn't have to fight fair. If you're the innocent person, we're more than happy with you having the decisive upper hand in a fight against somebody who's unlawfully trying to do you harm. So it really, comes down to the jury instructions that the judge gives. But, on that note, let me explain something. I went to law school for 4 years. I know it's usually 3, but I went in the evenings. Went to law school for 4 years, and we studied this concept, studied many concepts in criminal law. And then you get out of law school and you practice in real life and you still struggle with these concepts and why are they fact issues for the jury and not issues of law for the judge. And, I don't understand this particular form jury charge. I don't know if people know, but in the state of Wisconsin, many of the jury charges are just coming out of a booklet. Each section of the criminal code has a corresponding jury charge, the instructions, if you will, that the judge will read to the jury and say, the elements of the crime are A, B, C, and D, and this is what they mean. And if you find that those elements fit, they're satisfied, then you can convict the defendant. And that's basically how it works. However, what those jury instructions don't do is spell out what is meant by reasonable force in terms, of the self-defense claim here. So what we have is we have a prosecution who's trying to convince a jury or create a bias against what the average reasonable person would think would be appropriate for a victim to use in the case of self-defense. So that's the first thing going on here. We also have many mistruths going on. I don't know if you saw the testimony where the prosecutor asked a witness about the 5.56 round and said, oh, this is a very large caliber. Well, if you're talking a large caliber, whether you're talking, powder capacity, velocity, or you're talking about the width of the bullet, in many respects, the 5.56 is one of the smallest centerfire rifle cartridges on the market. By far the smallest that's commercially available on the average store shelf, other than a Wildcat or a homemade cartridge. So, that myth is still going around there, and unfortunately the courts are not equipped to deal with that. That's a matter of expert testimony that has to come in. They have to bring an expert in and say, no, he wasn't walking around with a 338 Lapua or a 50 BMG. This was what is generally considered, an acceptable round for self-defense, but in most states is actually banned for even hunting deer and mid-sized game because it's considered too small or underpowered or whatever it is. So you have that there. But let's get to the real crux of what the prosecution is trying to do in this case. The prosecution is really dealing with the concept of initial aggressor. So in self-defense, and I mentioned this in another video, you have the right to defend yourself against other people, but you don't have a right to really instigate or cause the sequence of actions in the first place. Meaning, you can't start hitting somebody and flogging somebody and then claim self-defense when they pull a knife or gun on you. You are the initial aggressor. You caused that confrontation to happen, and more than likely, that individual who acted in self-defense is going to be able to establish that there was a likelihood that you were going to engage in conduct that would have resulted in serious harm or death to them. Okay, we understand that. But there's also a concept in the law, and I'm interested to see how the judge is going to deal with this in the jury instructions, where even an initial aggressor can abandon the attack and no longer be the initial aggressor. There are situations where a person may slap you once or twice, and then you pull out a knife or a gun and they put their hands up and go, whoa, yo, dude, you know what? I'm wrong. You got me. I'm sorry. Turns around, starts walking away from you. That goes to the issue of imminency. Is this person now an imminent threat to you? Which I'm assuming this judge is going to instruct on imminency in terms of self-defense. So in most cases, you would say, no, that individual is not an imminent threat to you. He's abandoned, and some states call it abandonment or surrender or whatever they call it. So he's abandoned his attack. He's turned around. He's starting to walk away, and he's no longer a threat to you or other individuals. So in that case, you don't have the right to use lethal self-defense. So use lethal force against that individual. You don't in most cases. So it's interesting what the prosecution's trying to do here. The prosecution here is trying to argue that Rittenhouse pointed his rifle at somebody else who was, I believe, carrying a firearm themselves. And that is what caused the chain of events for the first individual, the child molester, I forget his name, to attack Rittenhouse. So that individual, I guess the theory is going to be on closing arguments that individual was only attacking Rittenhouse because he was trying to protect other people from Rittenhouse because Rittenhouse pointed a rifle at them. The last piece of evidence that the prosecution got in was a digitally enhanced and altered image. There's conflict, some controversy as to the right of self-defense, and understands the concept that you don't have to bring a knife to a knife fight. You, as the victim in that case, can bring a gun to a knife fight. We want the victim to prevail. I gave an example in a different video. You're a woman late at night, leaving work late at night, you're in a parking lot, somebody is coming at you, either he's just physically stronger or he has a knife or other blunt object and he's menacing and threatening you, and you believe, probably reasonably so, that he will commit a rape or serious injury or murder upon you. Yeah, I think we would rather that woman have a firearm and be well skilled in it because we want that woman to prevail in that altercation. And I think that's a general concept as a society that we should have, if not just for the individual person to be able to protect themselves, but as a pretty good deterrent against those who wish to do us harm in society. So in the state I live, in the county I live, I can tell you right now, if I were to use a firearm in self-defense, even a very clear cut case of self-defense. I mean, assuming I have none of the baggage that comes along with the Rittenhouse case, people are questioning Kyle shouldn't have been there. You could kind of classify him as a vigilante because he was there to protect property. It wasn't even his own. I get that. We can have that argument. We can have that discussion. Sorry about that. I said one cut. We can have that discussion, and we can have that discussion all day long. But you need to understand, especially when people ask me, in this situation, if I'm in this situation and I use a firearm, or if I even display the firearm, which, under our new use of force standards in New Jersey, police officer, displaying a firearm, pointing it at somebody is considered lethal force now. And used to be constructive authority and this, that, and the other thing, but now it's considered use of force, and you have to do a use of force report. So, the definitions have changed here, and it's very important for people to understand that if you use force in a state like Massachusetts, Maryland, New Jersey, California, New York, you're more than likely going to be prosecuted. So, I know there's laws in certain states, in Texas and other states, where you can use force in order to protect property. And I guess in those states, if you live in the right county and you have the right sheriff, the right prosecutor, they're going to recognize the law and err on the side of individual rights and liberty and err on the side of the victim. But you have to understand, depending on where you live, you could likely get prosecuted. And you can likely get a prosecutor who, in this case, is going to try to impeach Rittenhouse on his taking the Fifth Amendment, which, the judge was right to get as upset as he did. And the judge stumbled right before he uttered the words, mistrial with prejudice, because I think the judge wants it to go to verdict first, because if it's a not guilty verdict, it doesn't have to be the judge dismissing the case. But yeah, it matters where you live. So the best advice I give to anybody, and I know there's a lot of people who give courses on use of force, use of deadly force, when you can use it, what's appropriate, what's not. It really boils down to the simple rule. If there is no other alternative to save your life other than the use of deadly force, expect to be sitting on a courtroom somewhere and being, judged by your peers. In this case, peers who live in the city that was looted and ravaged, and it didn't seem like anybody cared to stop it. So, what's the makeup of his jury? What would the makeup of my jury be living in, a urban New Jersey county? I have to assume it's people that don't necessarily share the same political or world views that I do, or views just on personal liberty in the first case. So, yeah, that has to be taken into account. And I think it's just best to go by that as a general rule, that basically, if you're going to use a firearm or any weapon or implement or use deadly force in any way, shape, or form, it has to be last resort, and it has to be no other option. And we can have the further discussion of whether, if you're a 17-year-old and somebody has a piece of property they want to be protected from looters and rioters, should you go down there and do it? I would say no. I don't, the issue here, though, is the prosecution's trying to make that out to be, that's the reason why Kyle couldn't use self-defense, is because he was in the wrong place at the wrong time. Well, that's simply not the law. I don't know how the judge is going to deal with that on the instructions, but I think the prosecution did a pretty bad job making it look like Kyle was just there because he wanted to live role play a video game. That literally was the line of questioning. I think he's going to do a poor job of that, and the judge was cognizant of the fact that Kyle had seen looters before. He called 911. Yeah, he may have made some flippant comments, but the actions leading up to that point were, he was, removing graffiti, trying to put out fires, and it was only until he ended up in that parking lot with a child molester and another individual, who now alleges Kyle pointed a gun at him, and that precipitated this whole thing. Okay, well, if Kyle pointed a gun at you and you so feared for your life that it was appropriate for a mob to start to descend on him, why didn't you point your firearm back or use your firearm? So, you know what? Whether the jury's going to be able to see those nuances or not, I don't know. But the one thing I think everybody should take from this is, there's nothing in the law that says that instruction gets given to the jury that way. The judge is not going to say, well, you know what? He's entitled to do this. The other individual acted unreasonably. No, they leave all those questions to the jury. And unless the judge determines, and this happens on appeal too, on the appellate review, unless they determine there was no evidence upon which the jury could have arrived to that conclusion, I don't care how much exculpatory evidence there is, if there was a minimum body of evidence upon which a jury could have come to that conclusion, don't expect the judge and the courts to step in and do the, beyond a shadow of a doubt analysis for the jury. They're going to leave it to the jury, and that is the real peril that you risk in using self-defense in many areas in America, and that unfortunately is the state of things right now. So if anybody has any questions, reach out to me. But again, remember, whether there are riots after this or not, if he gets convicted, I have a feeling the defense is going to move the mistrial motions, and they probably will be granted. We may end up with another trial. I think this judge has the grounds to dismiss the case and do a mistrial with prejudice. I think the prosecution, as the defense accused them, was really trying to get a mistrial in this case because they really botched a lot of the direct evidence in their case in chief. But I think this judge wants to let it go to a jury so that they can get a verdict. I think the judge believes it's going to be a not guilty verdict based on law of self-defense. So regardless of what happens, good luck to America in whatever aftermath comes.